Thank you very much for having me. I appreciate it. And I don't know about subject matter expert, but I do know a lot about guarantees and looking forward to talking about them.
Well, Robert, I know we had dinner the other night, and I think we were at the table for 2 hours talking about guarantees. So I would consider you a subject matter expert. So thanks again for coming on. To give you some background, I met Robert through the California Mortgage Association. It's an organization dedicated to education and advocacy for our industry, the private lending industry. Robert, I know, is a speaker and active with a number of other organizations. I'm going to name a couple here: the California Mortgage Bankers Association, the Mortgage Bankers Association, United Trustees Association, and the California Bankers Association. And then somewhere in between all of that, he works with lenders like myself of all sizes when loans don't go as planned. One more interesting thing I always like to bring up: Robert is a very good pickleball player. He's also a very good tennis player. I've not actually played tennis, but I did get on the court with Robert on the pickleball, and I was quite impressed with your skills, Robert.
Thank you. That was a good time, and I hope to do that again at the next CMA event. That was a lot of fun.
Well, let's do it. So I give you everybody kind of a brief background. Why don't you kind of jump into your background and what you specialize in?
Happy to. So I'm a founding partner, Wright, Finley and Zach. We've been going into our 22nd year. I can break it down most simplistically that we have 3 practice areas, and the first one is we help private lenders and lenders in general and their investors with litigation, bankruptcies, evictions, title matters, anything that can go wrong with a loan, or enforcing your loan documents, such as filing an action related to a guarantee that we're going to talk about, putting a receiver in place to collect rents. So that's our first practice area. Second was help private lenders with their compliance needs, regulatory issues, and licensing. Mm-hmm. And then lastly, we have a transactional team that helps put together any real estate or financing related contracts. So most loan documents are fairly standard. We'll step in when it's a more complex deal or there's some a high dollar deal and they want some customized loan documents, or even like a purchase and sale of a building or anything like that as well. In addition, I am my side gig is I'm general counsel for the California Mortgage Association as well. So that's probably more than you needed to know about.
Well, that's a lot that you cover. And again, we've got a lot to talk about today. So I'm going to jump right into it. To give all our attendees an idea here, I try to put these webinars together usually once or twice a month from industry experts like Robert to talk about topics and things that are affecting private lenders. So if you are investing in trust deeds, maybe you are investing in a mortgage fund or a mortgage fund manager, maybe a broker, that is in the private lending industry. These webinars are really focused on you to provide you some education and insight. This industry is growing and it's growing rapidly. So I feel that it's important to educate everybody in what's going on today because it is changing rapidly. So a couple things. I don't want this just to be a discussion or a lecture between Robert and myself. Highly suggest that you ask questions, add comments. We'd love to have more of a discussion type webinar. So you can do that. Most of you, I think the question area is on the left-hand side. Go ahead and submit those questions and I'll get to them. And Robert, I'll handle all the questions in terms of, I'll ask you those questions. So, and so let's go ahead and let's get started. So I know we want to kind of keep it broad at first. Why don't you kind of just talk about what is a personal guarantee and how is it involved in a private real estate loan transaction?
Yeah, I think that's a great place to start. So, I mean, at its core, a personal guarantee is exactly what it sounds like. It's a third-party agreement whereby the guarantor is agreeing to be liable for the performance of the other party. In our case, the borrower. So, in essence, the guarantor, often called a surety as well, is guaranteeing that the borrower is going to fulfill their contractual terms And if they don't, they agree to be personally liable in the event of a default. So it gives you a kind of a backup to just your note and deed of trust. You have this third party who is out there guaranteeing the borrower's performance.
Okay, and so these may be different than, let's say, if we have an LLC and you've got members of an LLC that are signing on behalf of the loan. That's different than what a member might maybe.
Exactly. So the most common time that you'll see a guarantee is you'll have maybe a fix and flip loan or a construction loan or any business purpose loan that's made to a LLC or a corporation or a partnership. And often those entities are single purpose, meaning that the only asset they have really is that particular piece of property. So what the guarantee will be signed by the owner of the LLC. So they're putting their own financial resources behind the project that they're putting on, that they're putting together, and behind the LLC's performance.
Okay. So you may be getting guarantees from the individuals within the LLC, and then you may actually be getting guarantees from people outside of that LLC.
Exactly.
Okay.
And sometimes the guarantees, it's a living, breathing contract. It could be amended, it could be changed. So like at times we'll have one party guarantee at origination, but then later on when we're doing a modification or something or an extension, we may end up adding an additional guarantor as well.
Oh, interesting. I want to hit upon that later because I know we're going to share some stories. We're going to do some real life events that have occurred. So, so who can be a guarantor and who cannot be a guarantor?
So basically anyone can be a guarantor except the borrower. So I've seen actually some loan docs where they try to make the borrower guarantee their own loan. It doesn't really make a lot of sense, but the borrower can't, because the borrower is already committed to being your borrower and committed to pay the debt. So it'd be anyone other than the borrower.
Okay, so if like Brock VandenBerg went out and got a loan, I'm not going to be a guarantor on my own loan.
But your dad could be, or a friend could be, or I could be. I won't, but it could be theoretically.
Okay. So what does the guarantee bring? I mean, we all ask for a guarantee. I don't think a lot of people understand really what it can do for you as a lender.
Yeah, so it's a separate contract. That's important to keep in mind. So you have your note and deed of trust. That's between you, the lender, and the borrower. The guarantee is a separate document completely. It should not be included in the note and deed of trust. Okay. And what it gives you is that in the event of a default, the lender or investor isn't just limited to the property. They can go after the guarantor directly for repayment of the loan. And this remedy exists regardless of whether the property is underwater, if there is sufficient equity, or if you choose to foreclose or not. You don't have to foreclose to enforce your guarantee. You could just go straight to the guarantee, sue on that, and recover your money that way, and never even foreclose if you want. So going after the property and suing to enforce the deed of trust they're just two entirely different things.
Now, going into now we're starting to get into some of the weeds here. Can you be doing that at the same time? Can you be enforcing or going through a foreclosure action and going for an action against the guarantors?
Absolutely, and I often recommend doing so. So usually your foreclosures are going to be non-judicial foreclosures. So you have a foreclosure trustee, often not even a lawyer, who is doing the foreclosure, and they're going after the property. At the same time, we can start the enforcement process to go after the guarantor. And the reason that has some value is that if the property's underwater, then ultimately you may take a loss on the property, so you want to recover from the guarantor. But also, just from a practical standpoint, sometimes the borrower is ignoring you. They're not, the loan matured, they don't have the money, they don't have the capability, so they just let you go through the foreclosure process and even the pre-foreclosure process, ignoring you. But the guarantor, when you send that demand letter to the guarantor, it gets their attention. And from a practical standpoint, we find that it has a lot of value in forcing the guarantor to bring the loan current, to pay you off, to sell the property, to do whatever they need to prevent you from going after them personally.
Interesting. So let's say in a scenario, and I don't know if you've got a real world scenario here. So if you have an LLC, you've got your owners of this LLC, they've signed personal guarantees, and you have this other individual that's also signed a guarantor, not maybe involved in that LLC. Does there start to become friction between those two parties?
It can happen. Generally not, because generally the guarantor is the one that's controlling the LLC or the corporation or the partnership. So
Okay.
they are kind of one and the same. It's just that the guarantor has personal liability. So generally no. But that said, when you have a different situation where it's a third party that is guaranteeing it, there definitely can be friction. So, for instance, we had one recently where it was a property up on Wilshire in LA, and the borrower, well, I was getting too much into it. The borrower actually demolished our property because they wanted to build something else.
Okay.
And our client wasn't very happy about that because the property was severely underwater without the structure that was on it, and the construction was not moving forward, and it had been 2 years. So our client found out that it was demolished. Their recourse against the property, they weren't going to be made whole. They tried to work with the borrower. They contacted the borrower, very little response. And the borrower was a son. So his parents, this is actually like a $10 million loan. It's nice parents to guarantee it. But his parents guaranteed the loan. And so we sent demand letters to the parents, and that immediately got us a phone call from the son. And we were able to end up resolving. We resolved it actually by putting putting deeds of trust on 7 other pieces of property and adding another guarantor.
Interesting. Okay. So and maybe we didn't go through this question specifically, but it came up here as a question, and that is, are guarantees different by state? So if you are trying to go after a guarantee in California, would that maybe be different than in Florida?
Yeah, so I'm not licensed in Florida, so I can't speak to that. But we are, our firm, while I'm in our California office, our firm does cover most of the Western U.S., west of the Rockies, except for Wyoming. And in most of the Western U.S. states, the guarantor, the concept is substantially the same. And I would suspect that it's substantially the same in Florida. And to the extent someone has a question down there, I do have some good friends down there I can ask them to confirm that. But the concept is generally the same. And then there might be slight nuances in how you draft it. And there'll be slight nuances in how you enforce it. But the concept is generally the same. You have this third party who is guaranteeing the performance of the debtor.
Okay.
And one thing I'll say there, and this might be a nuance that you can see between states, is in California, there's 2 types of guarantees in our world, what we're talking about here. Guarantee of collection and guarantee of performance. So guarantee of collection would mean I foreclose and I take back the property at $2 million and the loan was $3 million, and I can go collect against the guarantor that extra $1 million.
Okay.
But I have to go after the borrower first. I have to foreclose, and it's just whatever my loss is. Guarantee of performance, which is how we recommend drafting your guarantee. Guarantee of performance is that the guarantor is guaranteeing that the debtor is going to perform, make payments, provide tax returns, whatever it might be. So the moment the debtor fails or the borrower fails to perform, that triggers the guarantor's responsibility. That's why it's much better. It's much broader.
Oh, interesting. Okay. Another question came in, and as a 50% member of an LLC that owns one property, would I need to guarantee a loan on the property? If yes, could the other 50% member and I temporarily change the membership to, say, 85-15 with me at 15%, then I would not have to guarantee the loan.
If you're the borrower in this LLC scenario, if I was the lender in that situation, I would ask both members of the LLC to sign the guarantee.
Yeah, no, I think that's I say that would be pretty common. I know there's this kind of idea that anybody below 20%, we typically may not have to underwrite. But I would say that for the vast majority of loans that we've ever done, that we're asking for personal guarantees from all the members in the LLC.
And that would be my recommendation. Now, and keep in mind, I'm an attorney, and I'm telling you what I want to see,
Mm-hmm.
and what makes my life easier, and what's going to help you enforce, your loan to get paid. I also understand there's the practical realities of, maybe you're out competing in the marketplace, and maybe someone doesn't want to sign a guarantee, or maybe one member doesn't want to, and then you have to make a business decision whether that makes sense.
All right. So, in what situations generally are you going to recommend requiring a guarantee? And for me, it'd be almost any situation that I'm lending in.
Yes, I would say anytime it's a business purpose loan, especially to an LLC or a corporation or a partnership, I would definitely if it was my money, I would want a guarantee on.
Anything that we as a lender, so as a private lender, you should know when drafting a personal guarantee. And it's interesting, there was at the California Mortgage Association, I think a couple of years back, there was some discussion about changes that had to be made within personal guarantees. And honestly, I can't remember what those changes were. I don't know if you remember that. Going back to, I guess, the initial question is what key items should we be looking for in that personal guarantee?
So the first thing is it should be a separate document. As I mentioned before, I've seen it in the note. It just muddies the water and really makes enforceability not impossible, but more difficult. It gives the guarantor a defense. So it should be a separate document. You want it to be, there's limited and unlimited types of guarantees, and generally you want yours to be unlimited. And that is it's just almost as simple as it sounds, just to put in there language in there that it's unlimited.
So limited might be up to a certain dollar amount. Is that
limited? Could be up to a certain dollar amount. It could be up to one property, because sometimes I see people get multiple loans to one particular LLC, and you'll want to have the guarantor guaranteeing all of those loans. I would still recommend separate guarantees for each one, but it's nice to have within each one in case for some reason there's a problem that in the guarantee they're guaranteeing any loans to this LLC. So limited, you want unlimited versus limited. And then one of the big things is, so in California, there's a code section. I think it's 2819. So Civil Code 2819. And in that code section, without getting in the weeds, it basically gives a guarantor in any context, not just in our world, but any guarantor, it gives them certain rights that they could demand things before their guarantee kicks in. So they could require, for instance, that the lender foreclose first before exercising their on the guarantee. They could even direct the manner in which foreclosure occurs, and if multiple properties, the order of those foreclosures. So luckily, though, there's case law that says you can waive that provision, that a guarantor can waive that. We can require it to be waived. So you'd want, and this is probably the biggest mistake I see, you'd want specific language in your guarantee that 2819 is waived. It's totally enforceable. Good case law on it. You just want to make sure that's put in there. And it's only a paragraph. It's not super complex, but we'd want to lay out what 2819 says, and then they're specifically waiving it.
That they have waived that. Okay.
Yeah. And then the other thing I would recommend, and this is more from a practical standpoint, is when you ask for the guarantee, I would ask for a personal financial statement from the guarantor. And this I rarely ever see, but I think it's really important. So imagine you're doing a 11-month bridge loan, or a fix and flip loan with a short, that's under a year, and then there's a problem, and 11 months later we're doing we're exercising your rights under the guarantee, and we go to, and then you file a lawsuit, and then it takes another year, and now we don't know if the guarantor has any assets.
Yeah.
So if you ask at the front end about those assets, I think at least you get a personal financial statement. In a perfect world, I would want them to update that annually, or even biannually. But at a minimum, I would ask if I'm doing an extension or a loan mod, I would also ask for the a financial statement, because at that point in time, at origination, the guarantor, they want the loan, they're willing to give you anything they want for it.
Yeah.
At loan mod or extension, same thing.
That well, when things start to go bad and they're not communicating with you, and you're trying to find out what assets they have to back this loan, I mean, it's too late by that time.
Exactly.
Yeah. All right. So we kind of talked about, I guess you want to dial back into kind of the process of enforcing a guarantee. You kind of spoke about it earlier. You know, here we are. I've got a loan on a on a fix and flip, and they have stopped making payments. It's mid renovation. I'm concerned about their ability to complete this project. So I start a foreclosure action. Walk me through the next step in my scenario of what I would be doing.
Yeah, I would take one step back, even before you start your foreclosure. So once there's a default, the borrower defaults on the loan, and at that point in time, if you're not successful in working out something with that borrower, or they're not being non-responsive, or the responses aren't adequate to you, for you, and you see this, you look down the road, you see this is going to foreclosure. Mm-hmm. At that point, if you have a guarantee, I would recommend sending a demand letter to the guarantor, and that doesn't have to come from an attorney. If the servicer is used to doing them, but if the servicer is not, then generally I would recommend having an attorney take a look at it and send it out. So it's a demand letter to the guarantor, and the demand's going to basically explain what the default was, explain that we're exercising our rights under the guarantee. We'll reference the paragraph of the guarantee, and that we are demanding full payment of the loan. Because we're not demanding them to cure the default. That's up to the borrower to cure if it's something that is curable. So here we're just asking for, hey, you owe us $2 million, and we want $2 million. You're not referencing foreclosure. You're just saying you guaranteed it. The loan's a default, and I want my money.
Okay.
The value of sending that's before foreclosing, is at that point, quite often we see that the guarantor pays attention, or they get the borrower to pay attention. And that often, just that letter alone, has a much better effect on bringing the loan current or getting it paid off than the notice of intent to foreclose that you send to the borrower.
Okay. Now, question came in. What is a bad boy carve out, and is that a form of a personal guarantee?
I'm not familiar with a bad boy carve out. I mean, I'm trying to think. Never heard that term before. Maybe they can expand in the question.
I think I've seen it in the context of like if there's no guarantee unless they commit fraud of some type, and therefore they agree to, okay, so look, you stole the money for the project. It's a construction loan. You stole the money. Now we're really going to come after you as the guarantor. But you know what? If the project did not proceed as normal, you did everything you can, there was no fraud, there's really nothing we can't go after.
Got it. Okay, so that would be what I would call a limited guarantee. It's limited to the situation where there's fraud. It's limited to the situation where they took the proceeds and didn't complete the project. I generally recommend a broader, unlimited guarantee, because why limit yourself to just that situation? And most of the ones I see, frankly, are unlimited. But it would work exactly the same. If it's limited to that particular issue or some other issue, it could be limited to the borrower filing bankruptcy. So it would work the same.
Another question: does the spouse sign the personal guarantee as well?
I don't generally see that the spouse has, unless the spouse is an owner of the LLC. Okay. But I have seen it in non-LLC type situations. So you'll have, the one spouse taking out the loan for construction purposes, perhaps in their own name.
Okay.
And the other spouse guaranteeing.
Okay. Because, I'm thinking through a scenario where all of a sudden your guarantor has no assets because he's now divorced from a wife or his spouse, and that spouse now has all the assets.
Yes. And so I think it would be good to look at that. Part of it's going to be, what are their, when you look at that financial statement, what assets do they have? And when that comes back and they show what the assets have, a lot of it's going to be community property, things like that.
Okay. All right. So we've sent the letter out. Things are not progressing. They're not communicating with us. We know we've got a problem. So take us the next step from there.
Yeah. So next is you're probably going to start your non-judicial and your guarantor action simultaneously. So your non-judicial foreclosure, you refer it out to a trustee. Notice of default goes to the notice of sale, foreclosure sale. In theory, it can happen in 111 days.
Okay.
And it's a fairly standard and fairly cost-effective, cost-efficient process. Going after the guarantor would be filing a lawsuit. So our office would draft a complaint where we reference the default, reference the guarantee, and then we would go sue the guarantor personally. And
but again, simultaneous. I mean, this is happened. This isn't foreclosure. We have a loss, then we start going after the guarantors.
And simultaneous meaning one could start a week before the other. They don't have to start the exact same day or anything like that.
Okay.
And then after we file that complaint, we serve it, and then the guarantor has 30 days to respond. And that's another key moment where a lot of times we get some traction on trying to resolve it, because maybe the guarantor didn't get our letter or ignored our letter and thought we didn't really mean business. Well, now they got a lawsuit.
Okay.
And so that's when they'll often step up and say, okay, hey, I do want to work out something, and they work out some sort of arrangement that pays off the loan or extends the loan, or something that the lender's satisfied with. If they don't, then they have, at the end of the 30 days, they have to answer the complaint. If they don't answer the complaint, we can go in and get what we call a default judgment. And that happens. It's surprising, but it happens that the guarantor will just say, I don't have any assets, I file bankruptcy, and they just let us take a default. We go in to the court, we prove up what's owed, and we get a judgment for that amount.
Okay.
If they file an answer, then
So,
they can dispute the lawsuit.
Robert, can I take a step back though?
Yeah.
How do you define a loss though if you haven't foreclosed on the property?
So we are suing them for the entire amount owed on the loan. Let's say the loan's for $2 million. That's what's owed. We are suing them for $2 million because it's a guarantee of performance, and they've guaranteed that we're going to get $2 million.
Okay.
It is up to and technically, under the various statutes and case law, we're entitled to a judgment for $2 million. And arguably, the borrower is not entitled, the guarantor is not entitled to an offset related to the value of the property. That said, from a practical standpoint, most courts are going to give the the guarantor a credit for whatever the property ultimately sells for.
So it's going to be placed on hold for some period of time, or?
Not on hold, because lawsuits take, if it's 30 days, they have to answer. If they don't respond, best case scenario, we're probably going to get a judgment after 90 days. But if they file an answer, we're probably looking at 6 to 12 months, depending on the level of their dispute, of their objection. So during that time, you're probably going to already have non-judicially foreclosed. So generally, when we get to the point of getting an actual judgment, a dollar amount, we've already non-judicially foreclosed, and so we know what
practically what that number is.
And there's something important there, though, from a standpoint not somewhat related to a guarantee because it affects it. It goes to your credit bid that you make at your foreclosure sale. Okay. If you know that this, you have a $2 million loan again, and you know that the property is only worth $1.5 million, then you're going to bid only up to $1.5 million. And that arguably then preserves $500,000 where you can go after the guarantor. There's arguments why we could go after more, and if you get into the property, you find out it was a worse condition, you can seek more. If the market tumbles a little bit, we could ask for more. But if you, it gives some guidance to the amount that you are entitled to, and some judges would actually limit the amount that you'd be entitled to that $500,000.
So, but again, why credit bid up to just $1.5 million? Why not the $2 million?
So generally, you don't. I would not recommend credit bidding up beyond what you think the property is worth.
Not what the original loan amount was.
No, there's several reasons for that, and one is related to the guarantee. But I'll start off with the practical reason. Practical reason: if this property, unless you really, really want it, if it's only worth 1.5 million, why? I mean, you'd be better off bid up to 1.5. You let's say you get it for that. That preserves that $500,000 without question. It also, for some reason, you have an insurance claim, or there's a title issue. There's what we call the full credit bid rule, and if you bid the full amount of your debt, you're deemed to have been satisfied. That arguably doesn't apply in the guarantor context, but if you bid up to full credit bid, I'm in there arguing with the court as to why it doesn't apply, and we don't want to be doing that. Mm-hmm. So unless the property is worth up to the value, I wouldn't bid up there. I would bid up to what you think the property is worth. And then if it's a single family, or if it's a residential 1 to 4, so like a fix and flip loan, mm-hmm. Then there's also our SB 1079 post
you get
bidding process.
Into that probably,
which I won't. We could spend a lot of time on that. But if somebody were to, if you bid 1.5, someone could come along and outbid you at 1.5 and $1, which is an argument as to why you don't want to underbid too much.
Okay, so what in a scenario that you don't end up with the property? Let's say someone does come in at $1.5 million and $1. How does that change the going after the guarantee?
It helps fix. Well, in that situation, it does fix the amount that you're likely to recover from the guarantor, because now you know exactly what the property sold for, and that's your damage.
Okay.
So that's another reason to bid only up to the 1.5, if that's what you think it's worth, is then someone comes along, they outbid you at 1.6, and it limits your loss to 400,000, but you just got 1.6 in your pocket.
All right, so we foreclosed on the property, we established the loss, and let's just say the loss is for the loan amount. All right, you've now won the litigation. Now they. How do you go get the money? How do you do that?
And this is why that financial statement was so key, and why asking them to, or requiring them to supplement the financial statement is so important.
Okay.
Because you don't know what assets they have. I mean, we can do some searches online. We can see what property they own. We can, you can hire a private investigator, and we can even depose them and ask for, once we get a judgment, we can ask for all their bank account information and so forth. But we're chasing them, and we're kind of blind. Mm-hmm. So that financial information that you got at origination is really important. And again, updated later on at the loan mod or extensions stage. Or even if you're just talking about possibly extending it, asking them for a financial statement. Right. So the more we have, the better our eyes are, so we can go and we have this judgment in our hand. Mm-hmm. Once we have that judgment, we identify where those assets are. We can go in on very short notice, like 24 hours, and we can attach a bank account and take all the money that's in there.
Interesting.
We can garnish wages.
Have you done that? I mean, have you gone and
Absolutely.
Yeah. So you just go into a bank branch and say, here we go, here's the...
You actually have a writ, and the sheriff goes in there and does it.
Oh, interesting.
Yeah.
Now, how long do you have, is there a statute of limitations?
On enforcing your judgment after you've already, I'll answer the two parts.
It's actually two. Yeah. Is there a statute of limitations on both that you can go after it and then recover it?
Yeah. So on enforcing your guarantee, it's a contract. So generally it's a 4-year statute of limitation.
Okay.
That said, if the default is a monthly default, an installment payment default, every month is arguably a new default. So every month resets the statute of limitations. But that said, I mean, private lenders are not going to wait 4 years. I've never seen a private lender wait that long. I've seen some institutional lenders wait way too long, and loans get kicked around and things like that. So really, from a private lending standpoint, it's not an issue. But it is 4 years to answer your question. And then on the back end, once you get a judgment's good for 10 years. And then all you have to do is renew it, which is just a simple form that we submit to the court. And then once it's renewed, it's good for another 10 years.
All right. So
back, if I could finish answering your prior question, what you do is we also order, once we have that judgment, is we record an abstract of judgment in the county where the guarantor is located. And if we think the guarantor has property in multiple counties or states even, we can record an abstract in those counties.
It's one of those counties.
And that attaches to any property they own within a particular county. And I actually had one for, it wasn't a guarantee, but it was a judgment, similar situation. And I think it was like 7 years after, we got contacted by an escrow. And escrow is like,
they're ready to
sell
the property and they need to pay this off.
And they did. And the legal rate of interest is 10%, which now isn't nearly as good as it was then. But when your interest rate,
but it's decent.
Yeah, no, it's good. And it's just from the date of the judgment, it's continuing to accrue.
Wow. Okay. All right. So we all know this isn't cut and dry. People aren't, when that judgment comes down, there is a likelihood that they are going to declare bankruptcy. What happens then?
So this is probably the biggest knock on a guarantee, is if the guarantor does not have sufficient assets to deter them from filing bankruptcy, they can file a bankruptcy and get a discharge of any and all personal obligations that they have under the guarantee. Court's not going to give them that if they have a bunch of money and a bunch of assets.
Yeah.
But if they're essentially judgment proof, then they file bankruptcy, they walk away, and your guarantee is worth next to nothing. That's why
back to your original comment of, let's make sure that this guarantor has assets to go after.
Yeah. And
is it in their best interest to just file BK?
Yeah. And the one thing I do like about a bankruptcy in that scenario is that instead of me going and, instead of the lender incurring the cost and time associated with the guarantee or enforcing the guarantee, it's 6 months and you go through this whole process, or a year, and now I'm chasing the debtor around and it turns out they don't have anything. If they file bankruptcy, they have to disclose their assets.
Okay.
So at least at that point, I know pretty quickly whether they do or don't have assets. Mm-hmm. And I have the advantage of having the Chapter 7 trustee perhaps, or Chapter 11 trustee go, looking into assets as well. So it tells me pretty quickly whether there are assets or not.
Okay. Okay. Now, does a bankruptcy affect a foreclosure in a non-judicial foreclosure state?
So the borrower's bankruptcy does delay your foreclosure, of course.
Okay.
Everybody knows that. But the guarantor's bankruptcy would not affect your non-judicial foreclosure. So while the automatic stay would stop our lawsuit against the guarantor, it does not stop the
doesn't necessarily affect it, but I imagine it's going to happen. I mean, realistically would happen.
That the LLC may file bankruptcy as well.
Okay.
Yeah.
Well, would let's just say both parties. Let's say there's and the reason I keep bringing up that we have third-party guarantors is because in some cases I do require third-party guarantors on some of our fix and flip loans. So I have that outstanding party. But in your case, let's just say the guarantors are within the LLC. Are they going to file it at the LLC level most likely, or will they also file it at the personal level? Or is it just go hand in hand?
So they're a lot more likely to file at the LLC level. There's a little downside for them to file at LLC when that LLC owns one asset, it's this property. So that's often a strategy to delay the foreclosure, and it works. It delays the foreclosure, buys them some time, but ultimately it's not going to stop us from foreclosing. We're ultimately going to get relief, or we're going to get some sort of plan that brings us current.
Okay.
But on the guarantor side, definitely less likely that the guarantor is going to file bankruptcy, but definitely a possibility.
Now, does a guarantee affect the servicing of a loan. So, we have a third-party servicer. A lot of lenders may do it in-house. Servicing, for those that are on the call, simply means the collection of the payments from the borrower, and then maybe the distribution of those proceeds out to the investors. Does a guarantee affect the servicing of the loan?
Great question. If the loan is just chugging along and it's just payments are coming in and it matures and it gets paid off and all of that, the guarantor, the fact you have a guarantee means nothing.
Okay.
And it does not affect your servicing. Where it can affect your servicing is at kind of at 2 points. One is if you're modifying or extending or changing any of the terms of the underlying loan, when you're working with that LLC or whoever your borrower is, arguably, if you alter those terms, even if you made it more favorably, arguably the guarantor would have an argument. The guarantor would have an argument that by changing those terms, you've relieved them of their responsibility.
Even if they're the members of the very LLC of which you've now renegotiated the terms with.
And that's where the arguably comes in. I could say, well, they were on notice of it. But the way to avoid that is when you do an extension or a modification, you put a provision in.
Okay.
When you're listing, the parties, the borrower's this, the lender's this, you say the guarantor's this.
Okay.
And the loan was, the loan docs were executed on such and such a day for such and such a dollar amount on this particular property. You'd have another paragraph that says the guarantors guarantee the loan by executing a guarantee on such and such a day.
Okay.
And then you have you list all your terms of what's being changed or extended, and then you have the guarantor sign right after the borrower signs. Very simple.
Okay.
The second part where it comes in is back to your point earlier about when there's a default and when the servicer is looking at what should I be doing now to help my investor get paid, and instead of just having one option, which would be the non-judicial foreclosure, now I have a second option, which is also sending that demand letter to the guarantor.
Okay. Now, for us, I don't think I've done a loan where there isn't a personal guarantee in it. I never really had any pushback from borrowers. Is there any downside into getting a personal guarantee on a loan?
Legally, no. It absolutely gives you, two options, as I mentioned, and puts you in a better position to get paid, and not just get paid, but get paid quicker, which is really our goal. The only potential downside from a practical standpoint, if you're, the person that would be the guarantor, they're shopping that loan, and if they can get a loan, you're competing over rates, you're competing over terms, and if they could get a similar rate somewhere else and not have to sign a guarantee, you may lose out on that deal. Mm-hmm. Now, that may be good that you lost out on that deal, because that may be concerning that they wouldn't sign it, but that's really the only practical downside to it.
In a former life, I actually worked for a private equity fund, and we were doing mezzanine debt at that time. So we had our client base, our borrower base were mid-sized private builders. And these are builders that were building maybe 10 to 100 units. And that probably was one of the biggest, and this was between 2001 to about 2008. And that was probably one of the biggest negotiating points there, was recourse versus non-recourse loans. And what happened, I don't know if you remember this, remember the condo conversion craze? So everybody was out buying apartment buildings, and they were converting them to individual condominium units, and it was a big business. And then when the market tanked, you had all these partially sold apartment buildings. So maybe 50% were owned by individual owners, and then you had 50% were owned by the developer, the builder that bought that property. But a lot of these debt was non-recourse. So you had these builders just walk away, leaving these partially completed apartment buildings with the bank. So,
I could see it being a huge negotiating point. I mean, I know when, my partner and I were redoing our lease right now, and we've been in the same place for 22 years, and they don't ask for a guarantee anymore. And I love it. they used to, it's the Irvine company. They used to ask for a guarantee when we first did our first 2 5-year leases. And it's really nice not to. So that, from a practical standpoint, it could deter people from taking out a loan with your company. But that may be a deal you don't want anyway.
Yeah, and we did talk about at the end is why would an individual want to refuse to pay a guarantee? And I think you're right. It's a negotiating tactic or negotiating point on that guarantee.
Yeah,
I would say that's probably more common again in kind of the higher dollar amount transactions than you might see in some of the transactions at least we're involved with that are sub 3 million maybe.
Yeah. And to me, I mean, it would be a red flag as well if I was a lender and the guarantor refused to sign, unless they gave me a really good reason. But that would cause me some concern. Same if they wouldn't provide me with a financial statement.
Yeah. So, I mean, we've covered a lot of topics here. If anybody has any questions at this point for Robert, please throw those in the Q&A chat box. I'd be more than happy to respond to them. Robert, I had a lot of questions for you. Is there anything that I missed at this point that you think would be beneficial for our attendees today?
I think no. I would just say the biggest takeaways are make when you're an investor and you're out there you're placing your money. As Brock said, he's doing guarantees. Some other lenders, if you invest with multiple lenders, they do, but some don't. I would definitely want to make sure that if I'm going to invest my money, I would want to make sure there is a personal guarantee, and I would ask questions, as far as like, what some of the stuff we talked about here. Make sure that that whoever's servicing the loan, whoever's originating the loan, knows what they're doing in relation to that guarantee, like obviously Brock does. And that financial statement is probably the thing that I think most people miss. It's not common practice at all. In fact, I think it maybe seen one ever, but it's just so nice and it helps you out so much. And then the last thing to say there is the guarantor. The guarantee can come in handy also with just getting additional security for your loan. So where I see it is, okay, we have a project that's under, it's not yet completed. Our loan matures. Right now, it happens a lot in that the borrower can't come up with new financing because rates have gone up so much. You got this personal guarantee. The guarantor responds to you. They want to complete the project, but we're a little concerned because it might be underwater right now. They may not finish it. Having that guarantee can allow us to get other assets as additional collateral. So you go and we'll add 2 or 3 more properties as additional collateral in exchange for an extension of the loan or in exchange for additional financing if they need it. And that provides additional protection that you might not get if you didn't have that personal guarantee.
I agree. I wholeheartedly agree with you on that. So, Robert, thanks again for all the insight. I learned a ton. Hopefully the attendees here took away some nuggets of information. So, Robert, real quick, how can people get in touch with you?
Yes. Thank you for asking. So my email address, and I'll give it twice, but it's so Robert Finley is the name, and it is R Finlay, which is Finlay, which is a little different. Most Finleys are EYs, but we're an AY. So it's R Finlay, Finlay at Right Legal, which is WRIGHT legal.net. My work number as well, so if you want it is 949-477-5056. That's my direct line. Happy to answer any other questions regarding guarantees, receivership action if you're going after rents or anything else involving a loan or a piece of property.
All right, you got some claps.
I'd never seen that before. That's pretty cool. I like this new format.
Zoho webinar app, but yeah, I appreciate it. Got some happy faces. Now, again, this is great content. I really always enjoy listening to you at the California Mortgage Association. You definitely bring a lot of content there. Thank you for participating in the organization. And yeah, so any attendees, if you ever have any questions about this, Robert is again an industry expert. Please reach out to him. So if you got in late or you maybe missed our webinar, I'll go ahead. I've recorded the webinar. I'm going to go ahead and post it on the TaliMar Financial YouTube site so you can watch it in the evening when you're drinking a glass of wine and thinking about all the hard money loans that you're currently invested in. So I should have that in the next couple of days. And then I'll also follow up with an email with all of Robert's contact information. So, hey, thanks again, Robert, for jumping on. And I'll leave it last with you. Any last comments?
No, but if anyone, I send out industry updates from time to time on new legal issues that may affect investors and private lenders. So if you're interested in getting those, shoot me an email and I will forward them on. I will include you to our distribution list. We only do them when they're necessary, so you're not going to get overwhelmed with a bunch of different stuff. And I'll also reply with an article on guarantees that kind of recaps some of the stuff we talked about as well.
Great. So I'll go ahead and pass on his contact information. And please, I actually am on that mailing list, that email list. And there's a ton of great content that Robert shares with us. So I recommend it. So thanks again, Robert.
Everybody, have a great day.
All right. Thank you, everybody. Bye-bye.